Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-1793. Timothy L. Jenkins et al., appellants, versus Howard University and Howard University Board of Trustees. Mr. Temple for the appellants, Ms. Sager for the appellees.
Good morning.
Good morning, Your Honors. May it please the court, my name is Donald Temple, and I represent 10 alumni of our beloved Howard University. And I should say at the outset, their hearts are hurt that we have to be here today to bring to a challenge the bylaws of the university and the implementation and the following of them, as well as the students and the alumni that support them. We seek a reversal and remand here because the appellants believe there is no federal jurisdiction for this case to be in this particular court. In the alternative, we seek a reversal and remand and an instruction that the second amended complaint filed by the appellants below should be authorized and allowed. The standards of proof are known de novo on the jurisdiction issue, abuse of discretion on the remaining issues. I would say if the court's indulgence, and I think it's important if the court would indulge me, I'd like to suspend with facts, except for one critical fact, which is paramount in this particular case. The picture has been painted that the board of trustees has acted, and this is a board action. The primary act here, however, directed the court's attention to the joint appendix at 74, 31, 76, 78, 269, 270, and 345 is this. This action started not because the board made a decision, but because a committee of the board, the Governance Committee, on April the 6th, 2020, suspended the elections of students, faculty, and alumni that were in play. The alumni elections they began as a result of alumni protests and struggle in 1923, 24, and 25, culminating in a set of bylaws that were passed with negotiations with the alumni in 1926, as well as congressional scrutiny of that particular process. But that's not the issue. That particular committee chairperson suspended those elections without board consideration. The appellees have written and suggested that there was a board approval or the board announced this. The references that I've given to the court refute that almost as a matter of law. The Board of Trustees did not approve the recommendation of the Governance Committee chairperson. Nevertheless, the university suspended the elections of all of the stakeholders between April 6th and November 2021. As a result of the attrition naturally following the non-election of the alumni, students, and faculty, all but one alumni remained on the board when the board voted to remove alumni trustees. The point of that is that we've articulated very clearly in our writings the nature of the bylaws. There is no connection between the interpretation of the bylaws and the federal charter here, nor is there a violation of a federal statute or the Constitution here. This is a state law issue. And under both Gunn and an Empire Health case, which refute the arguments that the appellees raised in citing the Grable test, there's not a substantial federal issue here, nor is there.
Do you have a view on whether when Congress issued the charter for Howard University, was it acting as a national legislature, like for charters for Amtrak or the Red Cross, or was it acting as the local government for the district doing what local governments do, and that is charter corporations?
Thank you, Judge Millett. I do, and I thank the court for the order with the inquiry. It's our position that our beloved Howard University is a federally chartered institution, that Article 1, Section 8, Clause 17 which articulates the District of Columbia's, which articulates the congressional control of the District of Columbia, while it's in play in 1865, was not the basis for the charters or the creation of Howard University. And I put that in the context of the Reconstruction that followed the period of enslavement and the priorities that were taking place, beginning with the 1865 13th Amendment, 1866 Civil Rights Amendment, 42 USC 1981, the 1867 Howard emerging on the education front, and then 1868 the 14th Amendment, and then 1870 the 15th Amendment. So the Congress's intent at that time, though that argument does not necessarily implicate the appellant's argument, was to create a federal institution. However, we do not believe that that particular case, in fact, we believe that case benefits the appellants in the analysis, coupled with—
So I'm sorry, you say Congress was acting as a national legislature,
Correct.
creating a national university, and so therefore, I would see quite contrary to your position that there's no
well, actually,
federal law issue under the charter.
Well, actually, I don't think it's that simple, with all due respect, Your Honor, because it didn't create a national university. It created a federally chartered university. And at that particular time, the context
Was
has—
it doing the chartering because there was no district government to do it? Or was it doing the chartering because it was making a decision for the nation? Was it making a decision for the district to have this university? Because there's nothing in all you said about the history. I understand the timing, and it certainly makes perfect sense, but the charter itself just says we're going to charter this university, just like it says for Georgetown and GW and other universities in the district, because there was no one else to do the chartering.
I don't think that the analysis stops there, and I don't think that it's a quote-unquote national university. It is a federally chartered university.
Right, we all got that. I'm
But—
asking you, the question under the case we cited in our order is, in making that, it's federal in the sense that Congress did it,
Yes.
signed by the president. It's federal in that sense, but the federal government also served as a government for the District of Columbia. It had that charge during the relevant time period.
Well, Your Honor, the distinction, I see my time is very tight, but I'd like to point to the court's attention, the distinction between the 1871 congressional action referenced in that particular case, which created a District of Columbia government where it's specifically acting on Article 1, Section 8, Clause 17, versus the creation of Howard, the charter. And the reason why I said—
What power was it acting under when it created the charter?
under its congressional authority.
Well, I mean,
But that doesn't—
the authority you cite to create the district government is also part of Congress's authority. I'm trying to ask which type of authority.
Well, it's concurrent authority. Well, it's
Under the concurrent, and I'm asking which authority was used. Was it its control over the district as a seat of federal
well, the
government?
district didn't formally exist. My answer to your question, Your
I
Honor,
understand that.
is— my answer to your question is that it is a federally chartered institution, but more importantly—
That's not my question. That can't be the answer to my question, because that's not my question. My question is, in what capacity? Congress only acts in federal capacity.
and it's acting in its federal capacity. That's my answer.
What do you mean by federal capacity?
In its capacity to enact laws that are consistent with its policies and practices. And that is how it emerged, but not out of an interest of creating a university exclusively for the District of Columbia. What it did, it created a university that then became subject, as any other chartered institution located in a particular state, subject to the concurrent jurisdiction dynamics that we see exactly here, which then brings us to what the university is citing with Grable in particular, and that standard of review, which is applicable here. We believe that the Empire and gun cases, Supreme Court cases on the question of federal jurisdiction, notwithstanding district property, is the jurisprudence on the case law that governs here. And by that, that means that the tests that are applicable are the tests that the lower court applied, but we think erroneously, which are number one, the question of whether there's a disputed, whether there's a substantial federal question. And to the court's question, and the dichotomy that we believe is that just because there's a charter, a federal charter, doesn't necessarily, absent more, implicate a federal question. Additionally, in this case, unlike the case cited by the appellants, this case, the claim that was brought was brought under state law. It wasn't brought because there's a violation. We never said that the university violated its charter. It said the university violated its bylaws. Those bylaws, the university tries to say they're extended by the charter. The Congress set up this system by authorizing persons to set up a board of trustees. The board of trustees then passed these bylaws. The question is whether the violation of bylaws in the governance of the university implicate a substantially disputed federal question. We submit to the court that the case stops there.
Okay.
My
I
time.
know you wanted to, we'll give you a couple minutes for rebuttal.
Very well.
Thank
Thank
you.
you.
May it please the court, Joanne Sauger on behalf of Howard University. I'd like to start with the answer to the court's question. We think that Congress was acting in its capacity as a national legislature and created federal law in enacting enacting Howard's charter. We think there are three reasons for that. The first, you can look to the text of the charter and the text of its amendments. The second is the statutory context in which Howard was chartered. And the third is post-enactment history. I'd like to start with statutory context. In chartering Howard, as my friend on the other side noted, the Civil War ended in 1865. Shortly after that, Congress creates the Freedmen's Bureau. Congress then extends the Freedmen's Bureau for a year. And at the exact time at which Congress believes the Freedmen's Bureau will expire is when Congress enacts Howard's charter over presidential veto. And Congress names Howard University after the former commissioner of the Freedmen's Bureau. As you know, one of the major missions of the Freedmen's Bureau was educating newly freed slaves. As this former commissioner explained, it was very difficult to do that in the South. Congress was acting to solve a national problem. That's actually explained further in the legislative history of the 1928 amendment of the charter. You have the committee report, which specifically says that the justification for creating an annual congressional appropriation for Howard University is justified by two things. One is, quote, 45 years of congressional action. Those 45 years of actions are the 45 years of national annual appropriations for Howard University.
Let me go back to the charter and the legislative history. So Congress was doing a lot back then and certainly was doing things on a national scale, as you mentioned. But when it enacted the charter, before it did that, the senator said, I now propose to proceed with district business. And it did an amendment to the jail bill, which wouldn't be national legislation, and then it did Howard's charter. So it was doing Howard's charter at a time that it was doing district business. And then it went on to do, things for Foundry Methodist Episcopal Church. There's nothing in the text of the charter that sounds, if there's something in the text of the charter you want to point me to, but it simply says the University for the Education of Youth and Liberal Arts and Sciences.
Yes, Your Honor. Actually, on that,
any of the larger context that you're talking about in the charter.
if we're looking, sure, Your Honor. If we're looking at things that happened the same day, Congress also created the Department of Education that same day.
Yeah,
so
but did it say, now we're turning to district business? And that's kind of the relevant matter.
I
Before
don't
the Senate
have-
considered it, it said, I propose now to proceed with the district business. You can do a lot in a day, but it does things and it shifts
yes, Your Honor.
capacities. And so,
I think the best thing that I can point you to in response to that would be the legislative history of the 1928 amendment.
how does that tell us how the charter was? That's not.
It's
that's about
an amendment to the
appropriations.
charter.
But it's
though.
about appropriations. It's not, do you think it entirely recreated the university?
I do not think it entirely recreated the
happens
university, but I
sometimes.
do think that if you look at the committee reports there, the committee tries to explain what it is it's doing there and the national significance of Howard University. It doesn't just say, we are discussing exactly why we're formalizing this annual appropriation to make it in perpetuity. Instead, it says, we need to talk about why it is that it's important that Howard University be allowed to continue to survive and thrive and become a first-class institution. And the second reason that the committee report gives is, quote, the national importance of the Negro problem, end quote. The committee goes on to explain that, it believed that Congress had an obligation to African Americans that was, quote, even stronger than in the case of the Indian, end quote, because of the history of slavery and segregation. Congress thought it was, quote, of great importance to the country of having an institution capable of developing trained leaders for the colored race in all walks of life. On the other hand, this opportunity exists for white students in every state of the union. So
Right.
Congress really was trying to address a national problem. And even though
Stressing that there in 1920s based on making a governmental decision to appropriate money, which is different than appropriating the university as a national university.
I disagree, Your Honor, respectfully. And the reason I disagree is because Congress explains it needed to formalize this national appropriation in order to continue and assure the success of the university.
Is Congress
So
funding other HBCUs?
at that time, no, it was not through the same formal annual appropriation stream where there's a guaranteed line item in Congress's budget saying that it's going to provide
was
money for the university every single year.
Appropriations for other HBCUs or not?
There are different revenue
Modes
streams.
of getting there?
There are different revenue streams and they aren't annual in the same way. The only other university that has a line item in this way is Gallaudet University, which again is another university that Congress created to solve a national problem and deal with a special population whose education it didn't think was being adequately seen to on the state level. So yes, there are Pell Grants, for example, that go to different universities. There are occasional educational bills that seek to fund other universities, but the idea of a line item in every single annual spending bill having a line that refers to a specific university, that's just Howard and that's just
You said
Gallaudet.
they weren't rechartering it, so that's, I think, why don't we have to look at the creation of the original charter only?
Because
Deciding whether the charter itself is federal law for purposes of arising under jurisdiction.
sure, I think that it's, a relatively standard, ordinary tool of statutory interpretation to look at post-enactment history. And I think that the
No,
post-enactment
not
history.
really. Absolutely. Actually, there's a lot of cases that say we don't look at post-enactment history to say what a statute meant. There's more cases that say that than say otherwise that I'm aware of.
I disagree, Your Honor. I think when a statute is amended, we talk about whether in amending the statute, Congress speaks to wanting to continue a certain purpose or move forward with a different purpose or change purpose. And I think that what happened here is Congress
You
amends
have a
the.
new statute and you're interpreting the new statute. That's what you're doing. But that doesn't, you just said they weren't reincorporating it. They weren't rechartering it. So for purposes of what the nature of the charter was, now interpreting the appropriations, for sure, that's relevant. What they did is relevant to that because that's when they did it. But it didn't change, as you said twice, they didn't recharter it.
Your Honor.
It couldn't have changed characters. And legislators in 1921 cannot tell us what legislators in the 1860s were thinking when they did this charter.
That's true, Your Honor. But, there are many cases that say that when Congress touches a certain statute, decides to amend it, not amend it, Congress is talking about what that statute means. It is relevant to understanding the breadth of the statute, whether Congress is changing
What
the
is your
character.
best case that members of Congress talking in 1928 can tell us what the statute meant at the time it was enacted in 1867, if that history and language wasn't there in 1867?
Your Honor, I'd have to submit the best case to you right now. The case that I'm thinking of is Allen v. Milligan. The Supreme Court just said that in talking about the Voting Rights Act, when Congress reauthorized the Voting Rights Act, even though it didn't touch every single piece of the statute, the pieces that were untouched should be interpreted in a way
Authorization is
consistent.
different from adding an appropriate line appropriation.
Your Honor, I'll
So
have
they
to get
didn't
back to
recharter
you
here.
with my best case
But
on
don't
that.
you have a bigger problem? I mean, even if we agree with you that Congress was acting in its federal national capacity when it chartered Howard, that doesn't make this a federal case. I mean, these are state law claims. We're supposed to interpret the removal statute narrowly for federalism concerns, which I don't think are any different here just because this is a District of Columbia, not a state. You have the burden, and to the extent that there's a tie, you lose. I don't see any federal claim here.
Your Honor, I disagree. And the case that I point you to on that would be Bender v. Jordan. It's cited on page 20 of our brief. And in that case, this court said, in interpreting a breach of contract claim, which is similar to, I think, the type of claim that the plaintiffs are making here, that claim was undoubtedly a federal claim under Grable because the contract that had been entered into was a contract that had been entered into because of a federal regulation that required companies to enter into indemnification agreements between their shareholders and their boards of directors. And there was a dispute about whether some sort of reimbursement was needed for legal expenses. And this court said, well, of course, the contract, understanding the terms of the contract, you need to look to the regulation that required them to enter into the contract. I think that's exactly what's happening here. If you look at bylaw 1.
To the charter to answer anything about any of the claims in the first amended complaint.
Sure. So the first line of the bylaws is that the powers that are being exercised here are the powers that are granted pursuant to the charter. And then, there are various claims in the plaintiff's complaint. I think my best point on this would be the quorum issue. As you heard my friend on the other side stand up and say, they think that there is some sort of flaw with respect to how the bylaws were amended because a certain person or a certain number of people were not seated or were not noticed at the time. The charter specifically says that the board can conduct business of the university so long as it has a quorum of 9 members, any 9 members. I think it would be very difficult to adjudicate a breach of contract claim without understanding what the asserted contract is. And here, understanding the terms of the asserted contract requires looking at the charter itself. So
Ms. Cigar, even if we thought that was a federal question, why is it substantial?
it's a
Why
substantial.
is it substantial in terms of being, implicating federal law?
Yes, Your Honor. As Grable and Gunn explained, substantial refers to the government's interest in it. I think there is a substantial federal interest in here. You don't have to look to the number of people affected or the geographic area affected. That's Gunn. Instead, you look to how heavy the federal government's interest is. I would point to several different things that indicate that the federal government's interest here is strong. The first of which I would say is, Howard is statutorily obligated to provide an annual report to Congress and the Department of Education. I'm only aware of one other university that has that requirement. That's Gallaudet. The Secretary of Education is also a member of Howard's Board of Trustees and has attended Howard's board meetings in the past. I again, am not aware of any other institution that the Secretary of the Department of Education is statutorily required to be a member of.
Howard has obviously has links with the federal government in terms of its funding and appropriations, but how does this court possibly interpreting the charter raise a substantial question of interest to the federal government?
Sure, Your Honor. I think that the
Just because Howard has, an affiliation with the federal government doesn't make our interpretation of the charter a substantial federal question.
Your Honor, I think it does. So, for example, plaintiff's claims could easily have been that the board was not able to conduct business unless the Secretary of Education was there. They're speaking about a specific member of the board that they think should have been in attendance. The Secretary of Education is one of those members. And so I think it's the federal government has a substantial interest in this specific running of this specific board. Congress has reaffirmed its interest by amending the charter and by enacting various.
The federal government has a substantial interest. That's not the test. It's whether a substantial question of federal law is implicated. The federal government has a substantial interest in all kinds of very important private companies, but that does not make things involve them. So I don't think that's where's a substantial question or substantial federal inquiry that has to be taken here.
Yes, Your Honor. To continue on the example that I was just discussing, the interpretation of federal law there would be the requirements of the charter with respect to quorum, whether quorum requires specific people to be in attendance. As you know, sections 3 and 4 and 7 all refer to specific quorum requirements.
The charter is going to answer anything in this case. At most, it's going to be a fight about bylaws. The fact that the charter authorizes bylaws isn't going to be, no one's going to question that the charter authorizes bylaws. Are the bylaws federal law?
No, Your Honor, the bylaws are not federal law. And
bylaws they can't create a arising under jurisdiction.
The bylaws, I believe, do create, in this particular case, arising under jurisdiction because the claim that's being brought by the plaintiff cannot be adjudicated without referring to the charter. They can't win, Your Honor, unless they explain.
It's the charter that's doing it. If the bylaws themselves, you're not arguing either that they create federal law for purposes of arising under jurisdiction or that the bylaws by themselves would satisfy the fact that someone wants to fight over the bylaws would create a substantial question under Grable.
No, Your Honor, not every fight about the bylaws is going to create a substantial question under Grable. But I do think that just like in Bender, the interpretation of this contract requires reference to federal law.
Where does it require what is the requirement? There's no reference to the Secretary of Education in the charter, is there?
In the charter requires reporting to Congress. It's later a statute that requires
That's got nothing to do with their argument, but they're not saying you didn't file a report with Congress.
they are saying there wasn't a proper quorum, Your Honor, and the
understand
quorum
that's-
clauses, yeah.
That's, okay.
And that
Does
the charter
gonna
answers that question.
and says
Yes,
there's a
Your
proper
Honor.
quorum?
The chart, so if you look at the charter at section 4, I believe. All meetings of said board may be called in such manner as the trustees prescribe, and 9 of them so assembled shall constitute a quorum to do business, and a less number may adjourn from time to time.
Mhm.
The charter answers the question of how many people need to be there to do business and who needs to be
Well,
there to do
As
business.
the board may so authorize, and that gets us to the bylaws.
Your Honor, it doesn't say as
Sorry,
the board shall so authorize.
where are you reading it? I thought you said.
I'm looking at the addendum to my brief, addendum page 3.
No, it said where-
They shall appoint, it's section 4. Section 3 is the one that references
No, all
bylaws.
meetings of said board shall be called in such manner as the trustees shall prescribe. And 9 of them shall be a quorum. And so what I'm saying is manner as trustees shall prescribe. I assume they prescribe it through bylaws. Is that right?
I'm not seeing the shall.
Sorry, the
prescribe.
last sentence in section 4?
Oh, shall may be called in said that the meetings may be called in a manner such as a board shall prescribe, sure. Yeah, and 9 of them shall be assembled to be a quorum to do business. And if you look at, the bylaws that they're citing,
Okay, less
page
number
1, section 1, page 1 of the bylaws at JA 114 say, the board is exercising all powers and authorities conferred by its act of incorporation. I just don't, I don't think it's possible for a court interpreting the bylaws to understand whether the bylaws have been violated, which is the claim they're making, without referencing the charter. I mean, to reference an example that might be more familiar to Your Honor, it's as though somebody has brought a case saying that an agency acted ultra vires by violating one of its regulations. You would, of course, look to the organic statute of the agency to answer that question. That's the same type of relationship happening here. Somebody's made an ultra vires claim about a regulation, essentially, and you're trying to look at a court would need necessarily to look at the organic statute to decide whether the regulation was violated, whether the agency was actually acting ultra vires. That's exactly the claim being made here. It's ultra vires. Your Honor, if I could just offer one other answer on the court's question. The court had also asked about whether Congress was acting pursuant to its national power or its local power. I would also note that in the years after the Home Rule Act, Congress enacted significant legislation relating to Howard, including the establishing the Department of Education. When it most recently changed the Department of Education, it provided powers to the Department of Education relating to the, quote, laws relating to the relationship between Gallaudet College and Howard University and the American Printing House for the Blind. Also in 1984, Congress enacted another law concerning Howard's endowment. So Congress's continued activity in this space post the Home Rule Act, I think, is also significant. Finally, I'd ask Your Honor if it was possible to submit briefing on this issue. The court issued an order just a day and a half or so before oral argument that seems to be very significant to the court. We'd appreciate the opportunity to file something longer than a 34J letter or 28J letter regarding this issue.
Thank you. Thank you very much, counsel. Okay, Temple, we'll give you 2 minutes.
May it please the court. Your Honor, the appellees have made the case for the appellants. They have not cited one federal law that's implicated by the charter and the reference to the charter. They have alleged that you need to refer to the charter to interpret the simple question of whether the board acted without authority when its committee chairperson suspended an election for 18 months, deprived alumni, students, and faculties whose rights are articulated, more importantly, whose membership is required in Article 1, Section 2, to be on the board, and then to vote after they did that to remove them. That is a typical common law governance question for a nonprofit corporation that need not be adjudicated in this court. It does not. There's nothing that the appellant stated that suggests that there's federal jurisdiction. In addition to that, even the lower court judge in his ruling on the remand at footnote 3 stated that the parties seem to agree that there's a contract issue. There's nothing here. They haven't cited a provision in the federal charter that the court needs to rely upon to interpret a very basic governance question. We submit to the court that, and I underscore in the reference that we made, it is, they did not get up and say to you that the appellant is wrong. That independent individual decision was made and affirmed by the board. And when you look at the citations that we have, there are formal notes of recommendations that are adopted by the board. There's nothing, absolutely not a scintilla of evidence in this record which shows that the board made a decision to suspend these elections. We close with that and say to the court that this is not a case of all that, of other than what our Supreme Court has articulated in applying the Grable test that the appellees have cited in both the gun and the district and the Empire Health Choice cases. That, we submit, Your Honor, is the law that should apply. And with that, there is absolutely not here a disputed federal issue or a substantial federal issue that commands this court's jurisdiction.
Thank you very much.
Thank you.
Case is submitted, and the court will be in a brief recess.
stand, please. This honorable court is again in session. Be seated, please. Case number 23-5233. Stephen Thaler, an individual, appellant, versus Shira Perlmutter in her official capacity as Registrar of Copyrights and Director of the United States Copyright Office and U.S. Copyright Office. Mr. Abbott for the appellant, Mr. Crown for the appellees.
Good morning. May it please the court, my name is Ryan Abbott, counsel for appellant Stephen Thaler. This is a case of first impression, whether an original work generated by an AI system in the absence of a traditional human author is copyrightable. In this case, the work satisfies all the statutory requirements under the Copyright Act to receive protection, but the Copyright Office has denied registration by reading a requirement into the Act that does not exist. Nowhere in the Copyright Act does it say that a work requires a human author, much less a traditional human author, as the office is now requiring. The Copyright Act does not define the term author, and it expressly permits non-human authorship by allowing corporations, governments, and other non-human entities to be authors.
I don't understand why you're saying this does not involve a traditional human author. I mean, the administrative record document says that there was no human involvement. This was completely autonomous.
Well, you're
So in your theory for authorship wasn't that Dr. Thaler was an author and the machine assisted him in authoring or something, some sort of work for hire or some other sort of theory. It was that the machine itself was completely the author. So it's not that this is a non-traditional human author. It's there's nothing human at all about this under your theory of copyright ownership.
Well, Your Honor, I respectfully would disagree with several aspects of that, and that does not accurately reflect the administrative record, although that is what the Copyright Office is saying. The record shows that, the Copyright Office's test is they will grant copyright if a human rather than an AI meets the traditional elements of authorship. And the submission noted that the AI autonomously made the image. That isn't to say that Dr. Thaler wasn't involved in it. The registration also said that Dr. Thaler made and used the AI to make the image. Now, this fit into the Copyright Office's test, which is not in the Copyright Act, which is
Hang on, so your application is author, creativity machine, author created, 2D artwork created autonomously by machine. And only thing for Stephen Thaler is ownership of machine.
well, that was in the registration form, and then there were a series of submissions in the request for reconsideration that expanded and elaborated on the role of this. And those submissions
Did you
explain.
change that then? So is that no longer accurate?
Well, Your Honor, that is accurate.
Okay, then it's autonomously made by the machine and Stephen Thaler's only connection is he owns a machine.
Well, no, Your Honor, that is not the full record. That was the one-page registration form. The submission explains, which is in the record, that the machine did the thing one traditionally associates with authorship, making directly the image. It also explained that Dr. Thaler built and used the machine to make the image. It's not claiming that he did.
But the machine acted autonomously. Have you changed, it says on the form that that the machine autonomously created the image?
Right, and I think, Your Honor, this may be having to do with how autonomously is used in computer science. It is automating the traditional act of authorship. So, for example, if I ask my phone, generate a creative image, and it does, the phone is automating the traditional elements of authorship. Nevertheless, there is a human originator who programs the phone to do that, who instructs the phone to do something. It is both true that the machine autonomously, traditionally conceived of the elements of authorship, and that Dr. Thaler originated it by building and using a machine to make the image.
Then why not just have Dr. Thaler say he's the author?
Well, that is one of our alternate arguments, that Dr. Thaler is the author, but the Copyright Office.
But you didn't put that on the registration form, and that's not the issue before us.
Well,
because the issue before us is that the Copyright Office didn't approve your desired registration the way that your client articulated it on the form.
Well, respectfully, Your Honor, we disagree with that. That was in the submissions and the request for reconsideration, that the copyright could also go directly to Dr. Thaler as the user, programmer, and owner of the machine that made the image. That is in the record. The district court did not acknowledge that. The Copyright Office has not acknowledged that, but that is in the submissions to the Copyright Office in the request for reconsideration.
The case before us, in your brief, is a creative work generated by an artificial intelligence system in the absence of direct contribution by a traditional human author copyrightable. Is that accurate?
Yes.
Okay. And so it's created in the absence of any direct contribution.
Well, I
Indirect
think,
is someone had to build the machine.
well,
Someone had to turn the machine on.
so one of the questions that poses
Is
for,
that accurate? What do you mean by direct contribution?
well, precisely, right? What does it mean to author or originate a work? The Copyright Office compendium says that if the traditional elements of authorship are done by an AI, you can't get a copyright. And that is the position of our case. The AI did do that.
Okay.
But authorship and originality mean that a work created and stemmed from someone and came as a result of someone's efforts. That is all also true, that if not for Dr. Thaler building a machine and using a machine to make an image, the work wouldn't exist. And so as the Copyright Office thinks of an author, he is not an author. As I would urge this court to consider an author, he is an author because all it means is Dr. Thaler caused the work to come about. But we did want to be candid that this was not done in the way that one, paints a picture. He instructed a machine to do something that it then did.
If I tell my printer, I turn it on, I purchase it. Let's say actually this is totally made up. If I actually knew something, I built my own printer. I turn it on. I pick something up, tell it to print. It's printing, and then all of a sudden it jams up. And instead of just reproducing information, out comes a smeary image created entirely by the machine because it jammed up. Have I made an indirect contribution to the creation of that smeary image work?
Yes, Your Honor, and I would say that
You
if,
say that I could get a copyright in that miscue by the jammed machine?
I would say if the work is original, then yes, it doesn't.
Original, yes, we'll say it's original.
Okay, then I would say yes.
It gets a smear like I do.
If you caused an original work to come about and you are the only human author, then yes, you would be the author.
On and asking them to do something that is actually not copyrightable.
Correct.
Copy stuff.
Well, and I think, Your Honor,
And out it comes, I have created. That's your argument here?
yes, Your Honor.
Okay.
Well, Your Honor, I
Like
think
the argument you presented.
in the creative process, one does things all the time that don't necessarily result in an intended outcome. And these remain original works. An originator literally means the work came as a result of someone's effort. Someone had possession over the work. And if this court is looking for a human author,
Right, result of efforts and possession are different things.
well, indeed they are. But in both cases, Dr. Thaler on the record would be the author of this. And both are consistent with the
I thought
definition of
your theory
authorship.
was this was a work for hire.
Well, that is an alternate theory that we're arguing, that under the work for.
That's not, again, where in the record did you say you're not just arguing for hire, which is what your application says? Where did
Well,
you?
these were in the request for reconsideration where it noted that the AI was the proximate author of the work and that it should go to Dr. Thaler either by operation of law or under the work for hire doctrine, or that he,
What operation of law would there be other than a work for hire?
by possession or accession.
Is it your common law property theory?
And it is a theory that applies to ownership of tangible and intangible property in a wide variety of
Ownership
contexts.
is not creation. What is your best case that ownership is what counts as authorship under the Copyright Act?
Oh, I'm not suggesting that ownership is what counts as authorship.
You just did. You just said because he owns it under common law, he possesses it, and so he's the author of it.
No, Your Honor. He possesses the work. Possession is a basis for ownership. Yes. Sorry, I got a little mixed up there. One theory of unowned property is if the AI made an image that's original and protectable and no one else owned it, then he owned it by first possession the way one owns unowned property by first possession.
That's not authorship. Unless you're calling it work for hire.
Well, which is why we argue that also he's
You
entitled
said
to
you
the
had
work for
two
hire
different,
doctrine.
I am getting profoundly confused by what your theory is here.
Our
So,
theory is
Work
that,
for hire, and that can, as a matter of law, make something created by one, like an employee, automatically the employer becomes the author or is deemed the author for purpose as a matter of law. I asked you for another, whatever, you said operation of law apart from work for hire would make him, I thought you said would make him the author. I don't care about owning, I care about.
no, that would make him the owner, not the author. I'm
Okay,
sorry.
well, we only care about authors today.
Right. And so there's three options for how authorship could work if the court finds this is a protectable original work, which we believe it is. First, that the AI is the author because it was factually the proximate creator of the work and that Dr. Thaler owns it by operation of law. Second, that Dr. Thaler is deemed the owner under the work for hire doctrine. Or third, that Dr. Thaler is directly the author because he is the originator of the work, even though he didn't make a direct traditional sort of contribution to the work.
That's just another way of your first argument. Your third is just rephrasing your first one. You
Well,
don't
the
have-
third-
I don't have to make any contribution to it. It can be autonomously created by the computer as long as there's a human that turns a machine on, maybe builds a machine.
Well, exactly. I mean, but that is a
Okay, but that's
contribution.
just restating of your first argument, and that is, that only works if the matter created by the image, the work is still, under your third theory, the work is still autonomously created by the computer. That hasn't changed.
That
All
hasn't.
you're doing is adding, you're reminding us that he built and owns the machine, and maybe turned it on that morning.
Well, no, Your Honor, under the third theory, he directly qualifies as an author by virtue of what he did, which was indirect, which was building and using a machine. Under the first theory, he is merely acquiring.
Building's got nothing to do with it.
Well,
I mean, sorry,
if-
Kodak builds cameras, and so therefore they can be the authors of pictures that someone takes with a Kodak camera.
well, in fairness, much like Burrough Giles, people are the authors of pictures that their cameras
No, the
take,
people
and
who
they're
take the photo, come on, the analysis there was all about the artistry and setting up the photo, the angles, the lighting, the image you choose to do, how you choose to do it, how you frame the person. That's not done by Kodak.
That's not done by Kodak, but that is increasingly done in an autonomous fashion, compared to
Right, we're back to the
Napoleon
autonomous
Cerrone.
question. All right.
I'll leave the remainder of my time for rebuttal, if that's all right.
Sorry, do you have any other questions? Do you have any questions, Judge Rogers?
No, thanks.
All right,
Thank
thank you. Can you start by telling us what the question is in this case, please? According to the administrative record?
Of course, good morning, Nicholas Crown for the government. The question in this case is narrow to whether under APA review, the Copyright Office correctly denied a registration application that claimed on its face that the work was autonomously generated by an AI and identified as the author, not a human being, but the AI. Now, Judge Wilkins, you asked some questions about what was in the administrative record. I think you're exactly right. There are a couple other citations I'd like to give the court, maybe working backwards, in the district court. In fact, at the summary judgment stage, Dr. Thaler asserted it was an undisputed material fact that, quote, there was no issue of human involvement in this case. That was the basis on which the agency rendered its decision. It made that clear in footnote 3 on second reconsideration that it understood that there were no questions of human involvement. Dr. Thaler was not claiming that he was the author of this work. Instead, his theory, this was a test case, he was asserting that an autonomously created image that was generated by a non-human AI was the author. As we pointed out in our papers, as the agency pointed out on first and second reconsideration, and as the district court pointed out, the statutory text and structure make clear that authors are human beings. As for the other theories that Dr. Thaler has presented here, for example, the work made for hire doctrine, that just doesn't work. The Supreme Court made clear in the Reed decision, there are two mutually exclusive ways in which you could have a work made for hire. Dr. Thaler doesn't make any arguments that this was a specially commissioned work because he concedes his AI can't enter the contracts or the arrangements necessary there. And again, he conceded that his AI is not his legal employee.
Can I just ask a procedural question?
Of course.
If the registration form says one thing and then the Copyright Office denies the registration and the applicant moves for reconsideration and they have a different theory, like they started saying, well, I'm the author, for whatever reason that gets denied, and then they say, okay, under the work for hire doctrine, I should be registered as the author. Do they have to file a new registration form, or does the fact that they assert that in their motion for reconsideration kind of essentially amend their registration?
I think it depends on the circumstances. If it's an example here where the theory is diametrically opposed to what was on the face of the application and was the basis of the decision in the first place, I think it would be a tough argument to say all you're doing is supplementing or amending the registration. I think Dr. Thaler, in some circumstances, could generate a new image. He could file a new application, raise the same theories that he seems to be raising in federal court, but he did not raise before the agency in the first instance.
What does it mean to amend? I just felt, if I could, sorry, just follow up on that.
Well,
What's his amendment?
Yeah, as we pointed out in our brief, there are circumstances when there can be correspondence between the registration specialist and the applicant if it looks like on the face of the application there's been a mistake or something is not particularly clear. So in the AI context, as the agency made clear in its guidance document in March of 2023, there are circumstances when the agency will register works that contain AI-generated material, but that might require the applicant to disclaim certain parts of the work that was generated exclusively by the AI. And in those circumstances, you could have an amendment to the application where the new statement is disclaiming some parts of the work, while other parts can be entitled to copyright protection, or at least entitled to registration, which is prima facie evidence that you have a valid copyright.
One of your arguments in your brief was about the inability of machines to hold the property rights that come with copyright and license and to pass things on to heirs. How do you reconcile that with the Supreme Court's decision in Belford versus Scribner in the 1800s that recognized a copyright in a woman, even though a woman could not have any personal property rights?
I think there, what we're talking about is the 1976 Act. And what the question is here is whether authorship requires a human being. So I think
So
that's.
it didn't require someone who could have property rights in the 1800s, but it does now?
Well, no, I guess I'm coming up from a different angle. So for purposes of the 1976 Act, the way we know that an artificial intelligence or a machine, for example, my car, my navigation system, Siri, if I ask for weather updates, the way we know that is not going to be the author of a creative work is, among other things, because it can't actually have any of the rights that accrue to a human being as recognized in the 1976 Act.
A young child creates something.
I think
They
there are.
can't have property. I mean, their property, they aren't of the age to consent to anything or to exercise property rights. It all has to be done by someone else.
I want to be clear what we're talking about here, because I think there is a distinction between having property rights and being an author. So for purposes of authorship, what the Copyright Act requires is there has to be some level of originality, which the Supreme Court has explained involves a level of creativity. I think a human child could exhibit, but for purposes of the Copyright Act,
A machine creates something that's original and has some element of creativity. And so that's why I thought part of your argument was looking at the structure of the statute. It has all these references to sort of property, handling of property and treating the Copyright Act or the copyright that you obtain as a property interest and passing it on or licensing people to use the material, which
sure,
couldn't do. And so I'm asking, how does that apply then if you have a young child or
Well-
someone who for whatever reason is under guardianship and can't exercise property rights?
well, even in the guardianship example, we're still talking about human beings. And as you pointed out, the Copyright Act does
A
allow,
human being or something that can hold property rights?
I'm sorry.
I thought your argument about property rights, do you have to be able, I had read your brief, and if I'm wrong, correct me, to point to as some of the textual indicia that you pointed to say that this statute envisions only humans holding copyrights. And part of that was humans can have property rights and machines cannot. Did I misread your brief?
No, and I want to be clear here. I think what we're talking about is authorship, which is distinct from ownership, of course. But in terms of the structure of the Copyright Act, I think you're right. What we're talking about here are all these things that indicate humanity as opposed to an inanimate object or a machine. So for example, children can
property rights.
Children can have under the Copyright Act, for example, they can have the rights to terminate a license passed on to them. So that's something that's reflected in the Copyright Act. But when it refers to an author's widow, an author's widower, children, grandchildren, that's all indicating humanity.
In the Scribner case, the Belfer versus Scribner, you're pretty clear you can hold a copyright even if you don't have personal property rights. So that was the holding.
And I don't think that's particularly informative of the 1976 Act and the dispute here. The narrow question is whether an AI can be the sole author of a copyright. And the answer, we think, based on the 76 Act's text and structure, the decisions from the Ninth Circuit and the Seventh Circuit discussing human authorship, and the longstanding interpretation that the Supreme Court has had since Sarony on down, including the Copyright Office's views from before the 1976 Act and consistent after the 1976 Act, all show that copyright authorship is a human endeavor. And again, that's why copyright duration in the standard case is going to be measured by the life and death of the author. And a machine doesn't have a life or death.
So you're using the kind of, presence of property rights as a kind of a way, an indicator that Congress intended for human authorship only, as opposed to saying that in order to be an author, you have to have been able to exercise property rights.
Right. It's one of dozens of indications that we think are present in the Act.
Do you know whether enslaved people were ever granted copyrights?
I don't know the answer to that question, but what I can tell you is in the 1976 Act that Congress enacted, again, that was about 10 years after the Copyright Office made clear its views that there's a distinction for authorship purposes between just the mechanical reproduction of something that a machine does versus human interaction and human ingenuity. 10 years later, Congress steps in and enacts the Copyright Act. 4 years later, it adds computer programs to the definition of literary works in Section 101, again, not disturbing the longstanding definition of authorship. In 1998, it extends copyright duration from 50 years to 20 years from the author's death. So again, all these indications that authorship is always required for the 1976 Act, at the very least, that there has to be some human input in creating the work.
Now, what about the argument made by appellant and also made forcefully by amici that your proffered interpretation of the act will, stifle innovation and create the wrong sorts of incentives?
I think a couple of responses to that. One, as we pointed out in our brief, I think the amici might be laboring under a misimpression that the Copyright Office will never grant registrations in the context of works that involve AI-generated content. But in terms of the policy arguments about what are the right incentives, what's the right balance to strike, again, as the Supreme Court recognized in the Georgia case, it pointed it out again in the Sony case, those are really questions for Congress to answer. So the Copyright Clause in the Constitution is a legislative grant of power, and within those limits, Congress gets to set its policy choices in terms of where the proper incentives lie. And I think for purposes of this case, when that question's not presented squarely here, when we have a hotly contested issues in terms of AI and what the proper incentives should be for intellectual property, those are really questions for Congress, not for this court on APA review of an agency decision based on this limited record.
Does the agency look
Well,
at,
I wondered whether or not the president didn't suggest that maybe the question isn't for a lower appellate court, but maybe the Supreme Court would be more responsive to the notion of what the original purpose of copyright was and some of the arguments appellant makes here. But as my colleagues' questions have re-emphasized and is in your brief, the question before this court is very narrow because of the way it was formed. So a lot of these intriguing questions really aren't presented for decision here. And I thought that's the way the district court treated the case as well.
That's exactly right. And I think there's wisdom in the district court's approach here when it recognized, based on plaintiff's own framing of this case, the case presents a very narrow question, and that's all the district court passed on. And we think that's the only thing that's up for review in this APA posture before this court.
So what's your response to appellant's argument that the district court, I can't remember the verb he used, but basically ignored the representations made in the petitions for reconsideration.
We respectfully but forcefully disagree with that statement. If I could just point out a couple of spots in the record, starting just with the complaint. This is JA 25, paragraph 18 of the corrected complaint. Plaintiff alleged, quote, plaintiff separately noted in the application that the work was autonomously created by a computer. Paragraph 22, this is JA 25, quote, the USCO, that is the Copyright Office, accepted that the work was autonomously created by artificial intelligence without any creative contribution from a human actor. So I don't see how the district court could have erred when it sees these representations made in the complaint. And you add to that JA 92, paragraph 9 of the motion for summary judgment, when again, plaintiff himself recognized that the only question that the Copyright Office passed on was the one presented in the application, and quote, there was no issue of human author involvement. He stated that as an undisputed fact. I don't think it's error for the district court to have taken plaintiff at his word, just as it was an error for the agency to take the application on its face.
Thank you.
Does the Copyright Office, when it receives an application for something that is created by AI, but in which the human has a role in contours of what it wants made, maybe the sources to which it points the machine, and the sort of type of images and colors and judgments about what it should produce? Does it look at those so the same way, some Vero Giles in the camera situation, or does it have as Miki seemed to suggest, a higher, stricter standard if AI is involved?
So I think the most recent views are in that 2023 guidance we cited and permalinked in our brief. But in general, yes, the answer is it's a careful inquiry based on the record that's before it. So things...
That doesn't answer. I'm sure it's always a careful inquiry.
Well, I think some of the questions that the Copyright Office would ask, if it had been presented in this case with an application like the ones that you posited, it would ask things like, well, if Dr. Thaler trained the machine, how did he train his AI? What prompts did he use in creating this work? What were the initial results? What did Dr. Thaler do in response to getting those results? How long did it take? Is this image just a carbon copy of something the machine had already been trained on, such that it wouldn't be original at all? Those are the types of nuanced and careful questions and analysis the Copyright Office would engage in if it's getting that type of application involving AI-generated works. But of course, that didn't happen here because that wasn't the theory or even the representations made in the application here. It didn't have a chance to make those types of determinations because Dr. Thaler presented a very different case.
Hey, Thaler AI, give me an image of a dog that's rainbow colored and a mix of 3 breeds. I'm trying to come up with something that I'm assuming is going to be original, which is hard in this world of the internet, but along those lines, give me something like that. Would that be sufficient to have the role of human creativity? I'm just trying to understand how it works in this context. I mean, I understand the factors you just said, but it sounds to me like it may be more exacting than it would be in a Vero Giles situation.
Yeah, candidly, I think the office does take a careful look. I just don't know. It's hard to say in the abstract what the office would do based on these circumstances because it will just depend on the particulars of the work and what the human did. But I think in terms of this test case, the whole point is you don't have to draw those lines. This is just an up-down vote on whether you have to have some human involvement in creating the work. We think the answer is yes for all the reasons we pointed out and as the district court explained.
The House and Senate each have task force or groups looking into AI. And this is extra record, so if you don't know, that's fine. I just didn't know, is the Copyright Office are they aware of communications with or working with Congress on legislation on this matter?
I want to be careful and answer your question accurately. I'm not aware of particular correspondence that has happened very recently. What I can tell you is that the office had a notice of inquiry to the public. I think that issued in August of 23. The comment period was extended. The office received 10,000 responses and it is working on a report that's going to assimilate and respond and provide views, including recommendations for Congress on what to do next based on a whole host of topics. I think the most recent volume 1 of the report dealt with digital replicas. So for example, the fake Drake song that came out, I think, over the summer.
There has been.
There has been.
Bills and things on those, at least already.
Yeah, and I'm not aware of any particular correspondence between the two.
Okay.
That's not in this record.
Are there any other questions? Judge Rogers, do you have any more questions?
No, thank you.
Thank
We
you
would
very
ask
much,
the-
counsel.
We would ask the court to affirm. Thank you.
Okay, sorry, no, Mr. Thaler. Mr. Abbott, we'll give you 2 minutes.
Thank you, Your Honor. And I think that this case has exactly the factual record for the important issues this case is raising and that they have been misconstrued by the Copyright Office and the district court. It is not.
Okay, so just stop right there. So when the district court held that you attempted to transform the issue by asserting new facts about what you were calling indirect control of the machine, and that hadn't been raised before the court or the agency, are you arguing that that was error by the district court?
Yes, Your Honor. I mean, for example, in appendix.
In your blue brief, do you raise a challenge to the waiver decision by the district court?
Yes, Your Honor. I mean, we do make the case that Dr. Thaler also directly qualifies.
No. So the district court, you made this argument to the district court.
Yes, Your
And
Honor.
the district court said you waived that. You didn't raise it before the agency.
Well, but that was incorrect.
Okay, and you get to come here and you get to argue to us that district courts made errors, but you have to raise them in your brief. So where in your blue brief do you dispute the district court's waiver decision on that issue?
Well, we didn't specifically use the word waiver, but
Okay,
in
where do you
raising that
dispute the
argument.
district court's ruling?
Oh, well, in all the
Reason.
sections about where Dr. Thaler directly qualifies as an author.
Making an argument that someone qualifies as an author is not the same thing as saying we adequately preserved this argument before the agency and the district court erred in concluding otherwise. That's a very different argument. Just making the argument here is a legal argument to us. What I'm asking you for is where have you challenged that aspect of the district court's decision?
Well, apologies, Your Honor. I think that is implied in our brief.
So we don't get to imply it. You get to either raise the issue or you don't. It's
But we
not listed
didn't-
in your issues presented. I see it nowhere in your argument about the claim of indirect authorship.
I think that's extensively in our brief, Your Honor, in
The
the,
challenge to the district court's decision? of
correct,
waiver?
Your Honor.
Point me to the pages.
I'd have to grab my laptop, Your Honor,
Okay.
because the brief's there. I can't remember the pages.
Or if you want to do it after argument, send a letter and tell us where in your blue brief
I will, and
you
brief,
challenge the district court's decision
I will
that you
do.
waived that argument.
And, you know, these facts were presented in answer to your question, the Copyright Office, the requests for reconsideration are a back and forth with the office. I mean, the one-page form is
I'm
very
asking
simple.
you where you challenged the district court's ruling that you've
It-
waived this argument. It
And I will supplement with an answer to that, Your Honor.
has to be in your blue brief,
It has to be in the brief.
and it can't be
And-
implicit. It needs to be in words.
And in the record, in the back and forth with the Copyright Office, for example, on Appendix 52, we say Dr. Thaler can also qualify. He is the user and the programmer of the AI that
The
made
problem that I have with all of this, and this is why I asked you the very first question that I did, is that all that's well and good, but your complaint doesn't say that the Copyright Office erred by denying our modified theory on reconsideration. Your complaint says that we assert that with no human involvement, we should be able to get a copyright, and the Copyright Office said no, and that's wrong, and that's arbitrary and capricious under the APA. That was your theory.
Right, and that does remain
So
our.
why are you arguing to us about, other things that were said on reconsideration that aren't in your complaint?
Well, Your Honor, I mean, there were multiple theories on which we argued in the alternate, and the primary one was that even without a direct human contribution to the work remains protectable. And the Copyright Office says, that's for Congress as a matter of policy. Our view is that the Copyright Office is making policy here outside of the statute, because nowhere in the act does it say you have to have a human author or a traditional human author or any of that. And the Supreme Court in Blaystein, among others, has cautioned if there isn't an explicit restriction in the act, then the work should get registration. So,
I wondered about that argument in terms of the traditional recognition by the Supreme Court that where Congress amends a statute, it's deemed to adopt the interpretations that are outstanding unless it makes clear that it's changing something. And here, we have legislative history where at least the House committee says that the Copyright Office has made it clear that it's not changing anything. It's not extending anything. It's not withdrawing anything. It's simply a continuation. And we, the Congress, are going to make several changes, like the number of years, that type of thing. So in that circumstance, Congress is deemed to have known about the interpretations by the Copyright Office and didn't give any indication that it disagreed with them. So if that is the legal framework in which we're dealing, then aren't the questions that my colleagues are pursuing with you as to the clarity of your claim, your theory, and of your claims of error by the Copyright Office as well as the district court, aren't they crucial for this court to be able to address the arguments you want decided? In other words, there's a whole process here, and you want to jump the process, and you may ultimately persuade, but we're a step away from it because of the way the case has been presented to us. We're 2 steps away in the sense of the courts deciding, much less the Congress deciding if it's necessary for it to act.
Well, Your Honor, I think with regards to whether Congress should act, I think current.
No, counsel, what I'm trying to get at is
Sure.
it's critically important for you to alert the court as to what the errors are. Not that, well, we made these general arguments about Dr. Thaler should be the owner, should be the author, et cetera. As distinct from pointing out where you raised these points and they were overlooked, either in error by the Copyright Office or error by the district court. I mean, that's what I think all these questions are going to. And my earlier question was trying to say that I think there are a lot of intriguing arguments you make, but the question is, are they before us? Have they been preserved for us to address them?
Right, and our view is they have, Your Honor. And with respect to the bucket of questions about nuance between what an AI does and what a human does, that's why I think the record is perfect for this court, because we are not, in that nuance, we agree with the Copyright Office. Our position is all that nuanced stuff is done by the AI, right? Dr. Thaler did not give a direct creative contribution to the machine. Under the Copyright Office's policy, even if they had fleshed that out, it would have been rejected. As to congressional silence, I believe, we've cited a case, I can't recall it off the top of my head, that Congress's silence is just that, silence. There's never been a case on which the Copyright Office has publicized denying an application for an AI-generated invention. So this is the first case. And even if buried in the compendium some time ago, this was a rule somewhere, I don't think we can deem Congress to have known and approved of that. When Congress did commission a body to look at this in the context of computer software and copyright, the commission said technology isn't advanced enough, that we don't have this kind of direct minimal level of human input into this. And now we do. So I don't think Congress has explicitly weighed in on this, but I think that the Copyright Act itself is clear that it's designed to accommodate technological progress, that is designed to accommodate the benefits of new technologies, and that, as the amicus brief discusses, every application the Copyright Office has gotten, they've disclaimed anything that generative AI has touched. So while our case is on the far end of the spectrum, that's what makes this an ideal case for a legal decision from this court about whether you need a direct traditional human author to make a work, and if not, then the work is protectable and belongs to Dr. Thaler under one of our theories.
What do we do with all Supreme Court? You talk about silence and stuff from Congress, but Supreme Court has said that sound policy as well as history supports our consistent deference to Congress when major technological innovations alter the market for copyrighted materials. Accommodating new technology is for Congress.
Well, yes.
The regulations of these relationships and any ultimate resolution of the many sensitive and important problems in this field must be left to Congress.
Well, and as you say, Your Honor, Congress is considering this matter and they may change the law, whatever this court decides. But current applicants have a right to an interpretation of the current Copyright Act because this is a widespread phenomenon now. People are using AI to make images and they should be protectable under the Copyright Act. There's no restriction against it. And if there's no restriction against it.
Rogers? Mr. Rogers, do you have any more questions?
No, thank you.
Any questions? All right, thank you very much. The case is submitted.
Thank you, Your Honors.
Case number 23-1237 et al. Acumen Capital Partners LLC petitioner versus National Labor Relations Board. Mr. Pikes for the petitioner, Mr. Odeski for the respondent.
Mr. Pikes? Did I say that right? Is it Pikes or Pikes?
It's Pikes, Your Honor.
Pikes, sorry. Okay.
Good morning. Lawrence Pikes with Wigan and Dana for the petitioner, Acumen Capital Partners. May it please the court. This appeal obviously arises out of a decision of the National Labor Relations Board, which in large part adopted a decision of an administrative law judge finding a violation of sections 8A1 and 8A3 of the Act, the National Labor Relations Act, in connection with Acumen's termination of the employment of Gregory Zapata. Our appeal is premised on the board's decision being essentially predicated on a faulty foundation, a foundation that's really built on nothing more than speculation. So the framework for the analysis, of course, is the right line test, which has three elements, only two of which are pertinent here, that the employer knew about the individual employee's protected activity under the National Labor Relations Act, and that that protected activity was a motivating factor in the employer's decision to take adverse action. And the board, the general counsel did not meet her burden of proof as to either issue. The knowledge question, of course, the pertinent knowledge being a knowledge of the decision maker. In this case, that's Mr. Rosenblum. The board focused extensively on the knowledge of a non-decision maker, Mr. Coppola, without introducing any evidence whatsoever to indicate that Mr. Rosenblum was aware of whatever protected activity Mr. Zapata engaged in.
We have numerous cases that say the knowledge of a supervisor is imputed to the employer in NLRB cases.
Well, that's basically a legal fiction to establish knowledge, but ultimately there has to be,
Excuse me, it was.
well, ultimately there has to,
Coppola an agent?
I'm sorry?
Is Mr. Coppola an agent?
The board found that he was an agent.
An agent and a supervisor, and that not his knowledge is imputed to the employer. And the employer is one that fired Mr. Zapata. I don't understand how you can say the knowledge element wasn't met.
Ultimately, perhaps this is better analyzed under the anti-union animus aspect of the test.
You talked about the first one, that's what I'm
Right.
asking about. And
Right.
So do you disagree? Am I wrong about that? I thought we had a lot of precedent that said knowledge of a supervisor was sufficient.
Well, there's case law speaks to the fact that ultimately the decision maker has to have some knowledge. And just because a low-level supervisor like Mr. Coppola had some discussions or a discussion with Mr. Zapata about the union's organizing activity, he asked him whether he was the one who brought the petition to the building, and Mr. Zapata said no.
You have a case where a supervisor had knowledge. I think you don't dispute that Mr. Coppola had knowledge of the union activity, right?
Yeah, the union was trying to, initially they were trying to encourage him to vote for the union. So he was aware of the activity.
There's no question there. Do you have a case where, because this would help me understand, because I'm misunderstanding our precedent, and that is, do you have a case where you said that's fine, but we don't impute the knowledge of a supervisor to the employer?
Right.
That's what I thought. I thought you were saying that we had to have cases say we have to have something more on the actual decision maker for knowledge.
Right, so we cited the Flagstaff Medical Center versus NLRB case from this court in 2013, which was also dealing with the issue of imputed knowledge by a supervisor. And what the court says is if the general counsel relies on circumstantial evidence and legal fictions about constructive knowledge, it does so to carry its burden of showing the decision maker knew about the employee's union activity. Permitting circumstantial evidence and legal fictions to trump direct proof to the contrary is absurd, is what the court said.
They had direct proof to the contrary.
Well, you had-
have direct proof to the contrary that he didn't know.
Well, first of all, you had Mr. Rosenblum's testimony, which was on,
Discredited. So
I'm sorry?
that was discredited. You haven't challenged that credibility determination. So
Well,
what direct proof do you have to the contrary?
I don't think his testimony that he was generally unaware of Mr. Zapata's involvement in the organizing campaign was discredited. There were certain aspects of Mr. Rosenblum's testimony that was
Generally unaware his
discredited.
role in the organizing campaign is not the same thing as saying he did not reasonably suspect that Mr. Zapata was supporting the union, interested in having a union.
But well, all the board pointed to in that regard, Your Honor, is the conversations that Mr. Coppola had with Mr. Zapata, where Mr. Zapata denied being involved in initiating the petition. What happened from there was that the ALJ manufactured a conversation by saying that Mr. Rosenblum denied ever talking to Mr. Coppola about union activity. The only discussion they ever had was the petition came to Mr. Coppola for some reason. He gave it to Mr. Rosenblum. That was the last they ever discussed the union petition, according to the testimony of both of them. So they both denied having any conversation about Mr. Zapata. And the ALJ went and said, well, I don't believe you. And therefore they did have a conversation, basically manufacturing a conversation that there's no testimony or evidence existed.
But just so we're clear, Rosenblum knew that there was union activity. It's not like Rosenblum didn't know that there was union activity.
That's correct, Your Honor, because there was a petition filed in early February of 2022.
And the petition could have been filed by how many people?
At that point in time, I believe it could have been filed by any one of four, if you include Mr. Coppola, who initially was seen, at least by the union, as part of the bargaining unit.
And at the time that Mr. Zapata was fired, how many of those four people were still with Acumen?
At that point, I believe there were three. One left at the end of January. Mr. Coppola was still there. And then I believe it was Mr. Garcia ended up leaving, I think it was in mid-March. So there were three that were still there at that point in time.
Shortly before the petition, Mr. Zapata had been in Mr. Rosenblum's office expressing labor grievances to him. And the ALJ and board relied on that as well, that when you have someone in your office just a couple weeks before complaining about working conditions, and it's this tiny little group, as Judge Wilkins points out, weeks later, a petition appears.
Well, it's your thing on the timing, because if you look at Mr. Zapata's
The
testimony,
question is whether the board or ALJ could rely on that.
I'm sorry?
The question is whether the board or ALJ, you said they just made stuff up. There was other stuff in the record to point to.
Right, I'm not saying the ALJ made everything up. I'm just saying that conversation was manufactured. But you alluded to the timing. When Mr. Zapata was asked on direct examination about that conversation, which was initiated when he saw an Indeed ad for basically what he thought was his position at a much higher rate of pay. And he met with Mr. Rosenblum about it. He was asked when that took place, and his answer was mid-March, which was after his termination. And the counsel for the general counsel funneled him into, well, you were already gone by then. He said, oh, well, late January. So the timing of it is a little bit uncertain, but
Are you disputing a fact finding now?
I'm sorry?
Are you disputing a fact finding by the board now?
Well, I don't believe the ALJ made any finding as to exactly when that conversation took place.
I thought you said late January, sort of 2 weeks before the petition.
That's when he ultimately said it was. But look, if you look at that conversation, right, he talked about the Indeed ad, and then Mr. Rosenblum asked him a few questions about how he enjoyed his job, right? And then he talked about how other employees, he thought there was a high turnover
Again,
because.
we're not making the fact determinations.
I understand.
We're not deciding what inferences to make from them. I've described to you what the ALJ and board did And so, and we know that Mr. Rosenblum was aware of agency, that there were, sorry, excuse me, labor activity, union activity, that there was a petition. Just statistically, it's kind of more likely to be, it's going to be one of them.
Well, he
Probably
didn't.
not a supervisor, and so, because supervisor's been around, hasn't done anything like this, so there's Mr. Zapata, his only other full-time one at that point? Was Mr. Garcia?
Well, at that point, it was a full-time, a part-time after.
He was the only other full-time one, Appellee and.
Right, and.
Yeah, the only full-time one. He's the only full-time there, and he'd just been in his office expressing grievances on behalf of the engineers. Again, we have a very deferential standard of review. I understand if the ALJ board had gone the other way, that would be, perfectly reasonable too, but that's not the issue before us.
Right, I understand. You used the term grievances, though. When he was answering some questions for Mr. Rosenblum, his testimony was, after they got past the advertisement for the position, was that he told Mr. Rosenblum that he felt that there was high turnover because of the benefits that were being
Why
offered.
everyone's leaving, your benefits and stuff, yeah, you're not
Right,
gonna.
right. Yeah, he was talking about other people, not himself, but.
He definitely talked about himself, he was just there for a pay raise. He wasn't supposed to get paid this much. You want to
Right.
turn to the animus issue?
Sure, and the evidence of animus, the primary bit of evidence that was cited as displaying animus is the conversation from almost a year earlier during Mr. Coppola's job interview when Mr. Coppola, who was a lifetime or longtime union member, had always been a union member, asked Mr. Rosenblum about whether there was a union at the building, and Mr. Rosenblum said this is a non-union building. Apparently, Mr. Coppola interpreted that to mean that he was not permitted, or Mr. Rosenblum didn't want him to bring the union in, and that's how he ostensibly communicated that conversation to Mr. Zapata. What Mr. Rosenblum said is clearly an 8C protected communication. He's simply stating that at most, he's saying that we do not want a union in our building. That is exactly what 8C is designed to protect. And keep in mind who he's saying it to. He's saying it to someone who the board has determined, the board advocated was and successfully advocated was a supervisor under the act, meaning that Mr. Rosenblum and Acumen had the right to demand complete loyalty from Mr. Coppola and tell him, if that was the message, do not bring a union in here and do not help employees unionize. That is perfectly lawful.
Well, he didn't even say that. He said much less than that.
I'm sorry, he didn't go that far.
Right.
Exactly. It was even less than that. And there's no element of coercion to that communication. That's the kind of communication that happens every day in a workplace where there's union activity among management and their supervisory personnel. I think that's kind of the key argument that they advance, which really is foreclosed by Section 8C. The rest of it is largely just the ALJ saying, I don't like the way this played out. The arguments about the vaccine mandate. I mean, Mr. Rosenblum testified that what changed was when the city fired over 1,000 people for not being vaccinated. Well, the general counsel says, well, they had put people on leave before then. There's no evidence Mr. Rosenblum knew about that. He certainly knew about the firings and acted based on that. Otherwise,
We do have this odd circumstance that it's pretty clear they weren't strictly enforcing this mandate until that time. And then calls Mr. Zapata into his office and Mr. Zapata says, look, I'm going to get it tomorrow. Now, having waited weeks and weeks and weeks and weeks, and the guy's going to have the vaccine and all I need is one vaccine to comply. And he's going to have it within literally hours.
Mhm. Well,
Like, I don't care. All of a sudden, I don't care.
first of all, the only thing,
Doesn't that allow for an inference that he wasn't really enforcing the vaccine mandate? He was looking for an excuse?
I don't believe so. First of all, Your Honor, Acumen did everything in accordance with the mandate except fire people, right? And they were only, at that point, Zapata was the
There's no
only one.
mandate to fire people.
Well, to remove them from the facility in Mr.
Well, it's
Zapata's
a very
case.
different thing.
Well, with someone who has no PTO left and is an on-site job, there's not really too many options. But I suppose they could have furloughed him. That's the one thing they could have done. But I mean, he
Could have furloughed him for half a day till he got a shot.
okay, right. But
Right.
at that point,
Oh, he's not gonna, you've waited all this time. He says, I didn't know you were enforcing this. I've got it tomorrow. What reasonable employer who's not looking to punish
Well,
this
we're
employee
looking-
wouldn't just wait for him to get the shot? Or when he gets the shot, say, all right, come back to work tomorrow. You're
well,
furloughed.
a couple of things, right? Mr. Rosen was sent him an email asked him to come to his office with his vaccine card or an application for an exemption. Mr. Zapata came with neither. At that point, Mr. Rosenblum wasn't interested in the appointment because it had been several weeks. So, keep in mind, when Zapata said that he was going to get the vaccine the next day, Mr. Rosenblum said, we'll reassess the situation after that. So
What evidence is there in the record that Mr. Rosenblum or Mr. Coppola told him several weeks earlier, because you said it's been several weeks, that he had to get that vaccine within a week or 2 or 3?
the posting said it, the December 27th
No,
posting.
Well, but they weren't enforcing that. There's evidence that and it's not rebutted by Mr. Rosenblum, that Mr. Coppola was saying it's not being enforced yet. And that lots of employees didn't. That same day, did he fire everybody who didn't have a vaccine, or just Mr.
Yes,
Zapata?
yes, because Mr. Zapata was the only one.
In the whole place?
There were only about 17 employees,
Mhm.
and everybody else had their vaccine, or one employee had left, although I think he got vaccinated before that. And
Where does it say every employee had?
there was a record that was being maintained by Acumen of folks who provided their proof of vaccination. That's in the record.
Mhm.
Zapata at that point was the only one who had not been vaccinated.
Okay.
So, also in terms of, well, why not just wait a day? Right? I think the circus case speaks to that same exact issue where the gentleman had not taken a mandatory medical exam, and he insisted he had an appointment or he was going to get it the next day or thereafter. And this court said, well, agreeing to overcome the reason that you're being fired doesn't mean that the employer didn't hold a good faith belief that your termination was appropriate at that particular time. This case is really no different than circus in that respect. So sure, Mr. Rosenblum could have done something different. He could have told him, you're on leave until you give me proof of vaccination. I think he was skeptical at that point as to whether Mr. Zapata intended to get vaccinated.
But
Or he could have done what he
wasn't there
did.
evidence that Coppola had said he would alert the engineers when Rosenberg was enforcing the vaccine policy?
Right, that was Zapata's testimony, yes. That was news to Mr. Rosenblum, according to his testimony, that he was.
Did Mr. Coppola deny it as well?
I don't know the answer to that, Your Honor. I don't believe
remember
Coppola was
anything in the
asked.
record to that effect. And of course, the small firm policy that the board applied, and all this was taking place right outside Coppola's office, which was in the boiler room.
Well, we're not contesting that Mr. Coppola had some knowledge of the union activity that was going on.
No, that wasn't my question. There was evidence that Mr. Coppola had told the engineers that he would let them know when Rosenberg was enforcing the vaccination policy.
That's correct. There is that.
And there's no evidence that they were ever told.
There's no evidence they were ever told beyond what was in the posting, which specifically said that you had to have the first dose by December 27th, 2021. But bear in mind, Mr. Coppola is allegedly making those assurances before anybody knows anything about union activity, before there's a petition on file, before the union rep shows up at the facility. So
That
in order
supports the board's position here.
well,
that
not
the
so,
two
I don't
were-
think.
The two were linked, and your argument is they weren't linked.
Well, exactly, because if we're saying that this is.
But you can't argue both sides, that's all I'm saying. You have
Right, I
to
understand.
choose.
Right. Right, I think the point, though, the critical point in terms of those supposed assurances is they were pre-petitioned, right? They're before anyone knows about union activity on site. So in order for that to somehow suggest there's an illicit motive here, right? It would have to be almost like they're trying to set Mr. Zapata up. Set him up for what? Like, they didn't know there was any union activity. So the assurances really don't tell us anything about Mr. Rosenblum's motive, at least in terms of anti-union animus. Nobody knew there was any union on the scene at the time these assurances are being provided. Otherwise, it doesn't really play into the analysis. The point is, it's essentially a pretext argument.
But
Right?
what about the argument based on the evidence that Rosenberg communicated with the engineers through Coppola? And this was standard operating procedure.
He did communicate through Coppola in regard to
So
their
isn't
day-to-day
he
activities.
subject to the fact that there was evidence Coppola didn't advised the engineers that Rosenberg was enforcing the policy.
Right, there was testimony from Mr. Zapata that Mr. Coppola told him that that he'd let them know when Mr. Rosenblum was going to be enforcing the policy. But again, those conversations all took place before the petition was filed. So if he's doing that, either at Mr. Rosenblum's behest or not, to try and set this guy up for a firing, it certainly couldn't be because of union activity, because nobody knew that was going on.
You say nobody knew. The board applied the small firm analysis here, and you haven't attacked that.
Well, first of all, these conversations took place before the union even showed up at the plant. So it was before the union organizer came to the boiler room, which I think was late January. These
I know,
assurances.
but the union issue was on the table from the beginning of Zapata's employment interview.
From a year earlier, there was some discussion with Mr. Coppola about the union. I mean, the small plant doctrine, what the board overlooked there, first of all, I've not seen a case where the board applied the small plant doctrine to establish an individual, this particular individual was engaged in protected activity as opposed to knowledge that union activity was in the works. But the elements of it, the only one that's met here is there's a small workforce. This is a huge building, 575,000 square feet, a full city block.
Everything's going on in the boiler room
Right. Well, again,
where
we're not talking about
Coppola's office is.
Right. I'm not doubting that. We're not arguing that Mr. Coppola had some knowledge here. The question is whether the decision maker, Mr. Rosenblum, had knowledge. He's up on the 6th floor, nowhere near these guys.
But
And
he
Zapata himself,
communicates and relies on Coppola.
the board's case
That's
relies
what the
on.
board said. And there's
Right,
no
exactly.
question that's documented in the record, is there?
Right. And I mean, it is undisputed that Mr. Coppola was not consulted on this discharge decision, which is not involved in the discharge decision. So at some level, to establish anti-union animus, that has to point to Rosenblum, because he's the lone decision maker here.
So
And
Mr. Coppola, in communicating to Zapata that this was a non-union building, would you say that's a protected statement? But that's all to be ignored?
that's correct, Your Honor. It is a protected statement.
And when Coppola says to Zapata, it's either you or me,
I'm not sure there's any real significance to that. Again,
well, he's saying either you instigated the union activity or I did.
well,
And Zapata says he didn't.
right. Well, but there's nothing unlawful about making that inquiry. I mean, the board didn't bring an
No, I
interrogation
know,
charge
but
for
we're
that
talking
reason.
about animus.
Right.
A lot of
Again.
innocent acts can show complicity. That's all I'm getting at.
Right. And it's a little
The court has
difficult.
consistently said you don't need direct evidence.
Right. It's a little difficult to imagine that a lifetime union member like Mr. Coppola harbored union animus, and then to impute that union animus to Mr. Rosenblum based on what, I
No,
guess.
no. You're mixing, and I suppose you're mixing concepts quite consciously. That's not the position the board took.
Well, the board certainly didn't identify any evidence of animus on Rosenblum's part. Right? They worked through Coppola to try and establish that animus. So apart from the timing, which alone doesn't prove an illicit motivation, right? They looked at this 8C protected statement, right? The fact that the city had put people on leave that Rosenblum knew, there's no evidence Rosenblum knew anything about. And the issue that Judge Millett alluded to in terms of they could have done things differently by putting Mr. Zapata on leave until he actually got his vaccine, which is really a matter of semantics. When Mr. Rosenblum told him when he got his vaccine, he would reassess the situation, and he was in the process of doing that, or at least considering it, and considering additional factors that came into play in light of Mr. Zapata's behavior in his office, when Mr. Zapata said, I don't want my job back, and that was the last time anybody ever heard of him. So there's no evidence Mr. Rosenblum didn't follow through on at least considering bringing him back after he received his vaccine in compliance with the mandate. At that point, the board's case crumbles. There's nothing there to establish anti-union animus infected this particular
There was
decision.
evidence that after afterwards.
I'm sorry, Your
That after Zapata got the vaccination, Rosenberg refused to take him back.
Well, he didn't refuse. There were some emails back and forth for about 2
Well,
days.
What, he didn't refuse. He didn't rehire him.
Well, he
No
did
question
not.
about that, right?
Well, he didn't tell him, I won't bring you back. The conversation ended when
Ah.
Mr. Zapata said, I don't even want my job back anymore. And he was never
No,
heard from
that's
again.
after
Yes,
sent 3 emails and Rosenberg never responded.
he did not respond to all of
Right.
those emails. I think he responded to
So
one.
his silence, he wasn't reconsidering, he wasn't putting Zapata back. Anyway, I don't want to belabor this point because our standard of review here is so limited.
Well, I certainly understand that, Your Honor. But this would be by no means the first case where the board concluded, the court concluded the board did not have substantial evidence to support a finding of a discriminatory discharge. The Stern Produce case from just a few months ago, I think, is a good example of that we've discussed in our reply brief. It came out after our opening brief, I believe.
Right.
Any other questions, Judge Rogers?
Thank you.
Thank you.
Thank you.
Guys, we'll give you a couple of minutes for rebuttal.
Thank you so much.
Mr. Odeski?
Morning, Your Honors. May it please the court. I'm Jared Odeski for the National Labor Relations Board. Substantial evidence supports the board's finding that Acumen violated the act by discharging Gregory Zapata. A reasonable mind looking at the credited evidence certainly could conclude, one, that Acumen's discharge of Zapata not 2 weeks after the filing of a union election petition was motivated by Zapata's union activity. And two, that Acumen failed to show that after 7 weeks of noncompliance with the city's vaccination order and 1 day before Zapata's scheduled vaccine appointment, it terminated Zapata because it feared penalization by the city. So the board's order is entitled to full enforcement on this standard of review. So starting first with unlawful motivation, the board's finding rested on 2 bases, both knowledge and anti-union animus. And as Your Honors acknowledged, with respect to knowledge, Acumen has conceded in its reply brief that record evidence supports the finding that Coppola knew of Zapata's union activity. That leaves 2 potential paths for finding that Rosenblum, the decision maker here, had knowledge. One of those is the well-recognized doctrine of imputation, where Coppola's knowledge was imputed to Rosenblum. And under that doctrine, as established in Clark and Wilkins, a supervisor or agent's knowledge is imputed absent an affirmative basis not to impute it. And here there is no credited evidence to that effect. In addition, we have Rosenblum's own reasonable suspicion.
Doesn't it matter kind of how high level the supervisor is?
So with respect to the doctrine of imputation for knowledge, all of the cases that Acumen cites for that proposition deal with this junior supervisor concept in the context of animus. With respect to knowledge, there's nothing in the doctrine that actually says, well, a low-level supervisor or a low-level agent, that doesn't matter because it's expected that it's going to be communicated up the chain. But in addition, here we have significant evidence that actually buttresses the imputation of animus. We have daily conversations between Coppola and Rosenblum.
Shifting to animus now from knowledge, or
I'm talking about knowledge, but
you said animus, so which?
oh, I apologize. Yes, so for knowledge. So there's significant evidence buttressing the imputation of knowledge, the daily conversations between Coppola and Rosenblum about this very small engineering workforce, the fact that Coppola shared the union election petition with Rosenblum, and they had a conversation about it. And then this also precedent for them talking about unionization in the context of the job interview. So it was a perfectly reasonable imputation based on both the doctrine, but also circumstantial evidence that supported
Is there
it.
any evidence in the record as to what the conversation between Coppola and Rosenblum was? About when they said they talked about the petition?
Yes, so on JA 167, there is just a note that Rosenblum says, we talked about Coppola being on compliance. And so there's nothing more in the record, but essentially, at one point, Rosenblum said, well, we actually didn't talk about it, and then he separately said we talked about it.
We don't
So
have any test evidence as to the content of that.
other than Rosenblum saying that Coppola was on compliance, but they did have a conversation about it. So we know,
That we don't have any basis for
so we know,
any even reasonable inferences about the content of that conversation.
well, we know
It's
that.
an easy question to ask witnesses at a hearing, and if they didn't have the information, they didn't have the information. It's just an empty record on the content of that conversation.
Well, based on the entirety of the evidence, we knew that Coppola and Rosenblum were having frequent conversations, had spoken about unionization before, which was another part of the basis for thinking that in that.
General conversation about unionization, you need knowledge of Zapata's union activity. And so you need some evidence, something.
So
Other than
Coppola.
They talked a lot, that he would have had a reasonable suspicion, at least, that Zapata was involved in union activity.
So we do have that with respect to Rosenblum's own reasonable suspicion, which he developed from the Indeed message and the conversation that they then had. So at the end of January.
Mr. Rosenblum testified that based on that conversation, he developed a suspicion.
No, but that was a perfectly reasonable
Why didn't someone
inference for
ask
the
him that
board to
question?
draw. I'm not sure of that, Your Honor, but I do know that, the board could reasonably draw the inference that if a conversation happened at the end of January regarding wages and benefits, and then several days later, a union petition comes forward. I also want to make a correction. At that point, there were only 3 potential engineers in the unit, one of whom was Coppola, a supervisor. You just have Garcia and Zapata at that point. It's a perfectly reasonable inference to think that Rosenblum had to suspect that Zapata was at least involved in this petition. So that independently establishes knowledge. But with respect to the imputation doctrine, I do just want to note that the different aspects I was talking about are all reasons that buttress the imputation, but the doctrine operates without any circumstantial evidence. If there's not affirmative evidence that imputation should not be applied, then it continues to go through. So next turn.
What about animus? Is that what you're turning to?
I'm turning to animus, yes. So with respect to animus, the board relies on 3 pieces of evidence. So one of those is Rosenblum's statement that then gets communicated out to Zapata in some fashion. So in this conversation with Coppola, Rosenblum says that one of the terms of employment here is that this is a non-union building.
Where did you say terms of employment? All I saw was the testimony that Coppola said, hey, I've been a union guy, what I do. And Rosenblum says, this is a non-union building, I think.
Right.
This is a non-union building,
That's correct.
which was a factually accurate statement.
So if devoid of any context.
Devoid of any context, in that precise context where the guy says, hey, I've been union, long time union. And he goes, this is a non-union building, and says nothing more.
And then on JA 125 and 126, Coppola does testify that Rosenblum then, in this context, told him the terms of employment. And this was also a job interview for Coppola. And so this conversation about, well, here are the terms of employment at the building.
He said he interpreted it as a term, but he never said that, there's no testimony that Rosenblum ever said this, keeping it not, just one thing to say it is non-union, but keeping it non-union is a term.
Well, so this is how Coppola understood it, and that's evidence of what was happening in that
Even if he did, it doesn't matter.
conversation.
He's a supervisor. It's perfectly fine to say that to supervisors.
So there's 2
How
reasons.
is it animus to say something that's perfectly lawful to say to a supervisor?
Sure. So one of the reasons is that even if Rosenblum thought that Coppola was a supervisor when he was hiring him as the chief engineer, and the record is clear.
Either was or was not a supervisor is a matter of law, all right? And the board's held, and there's no contest here that he was a supervisor.
Sure.
It was perfectly lawful. What he said was perfectly lawful to say to a supervisor. So how can that be? What is your best case that a perfectly lawful, factually accurate statement as narrow as this is a non-union building to someone to whom he's allowed to say that?
So it's the cases.
Animus.
Yeah, sorry, Your Honor. So it's the cases where the employer intends for that statement to be communicated out from the supervisor to employees. So
Where's the
here.
evidence of that he intended that?
So he hired Coppola as chief engineer, tasked him with onboarding employees and communicating directives from him, which is clear. And then Rosenblum, when he spoke to the engineers, or Rosenblum, when he spoke to Zapata, said the building was not union. Not that this
But he did that in
position.
response to a question from Zapata. He didn't do it as part of the onboarding process. Zapata asked and he responded.
And that
It's
conversation,
different than a directive as part of your onboarding process to tell everyone this place is non-union.
so it was early in Mr. Zapata's employment, and the conversation was essentially Mr. Zapata saying, how come we're not union?
Mhm.
And then Coppola explains the barrier because Rosenblum didn't want it in the building. Coppola, in fact, had wanted to be union, but he explained the reason we're not union is because Rosenblum doesn't want it in the building. And that's his interpretation of what Rosenblum had said, and that is the coercive statement that he communicates out.
That's from Coppola. It's not from Rosenblum.
That's from Coppola.
Could be
Yeah.
totally wrong about all that.
Well, Coppola, it was taking a conversation from context with Mr. Rosenblum, and under the board's standard for determining whether something is an
What's your best case that's analogous to that, that you have all Mr. Rosenblum who said is, this is a non-union building,
So
to someone who's a supervisor, perfectly lawful. And then how many weeks, months later?
about 8 or 9 months
8
later,
or 9 months later.
yes.
In response to a question, so not as part of onboarding. In response to a question, the supervisor says, this is my interpretation of that conversation. And that counts as evidence of animus on the part of Mr. Rosenblum. What is your best case for that?
So I think I would point your honor to Appellee Chocolate Company, which is a board case which
Do you have
talked.
any circuit precedent you can point to?
I'm happy to supply a post-argument letter to the court on that point. I do think the board has lots of cases.
I mean,
where
the
that
board did it
happens.
here, so I don't need
Yeah.
a board precedent
Sure.
on that. So
but
that's your one thing. What else do you have?
Yes. So also there's Coppola's accusation to Zapata.
But that's not evidence with Mr. Rosenblum.
So I think here the Acumen cites all of these cases with respect to, him being a junior level supervisor. I think that's a red herring here. He's not the junior level supervisor. This is a 13-person workplace. He's the supervisor.
For
the
animus,
engineers.
we have said that there needs, it's the cat's paw theory that's used in employment cases of all variety, that there needs to be some evidence that it was communicated to the decision maker.
And
You have
he-
animus. not
Here
knowledge.
that evidence is circumstantial. Again, Coppola and Rosenblum.
Is there any evidence that this, was it you or was it me, was communicated to Mr. Rosenblum?
Well, the timing of it is one. It comes after the
That's
union
not-
petition.
that-
And he comes
Every
and confronts
conversation
him.
that happens after the position, we're going to assume was conveyed to Mr. Rosenblum?
No, but I do think that with respect to, that he delivers the petition to Mr. Rosenblum.
You've got no
Coppola does.
evidence. Like, the problem is you've got no evidence. You keep pointing to Mr. Coppola, but there's no evidence that his animus was communicated to Mr. Rosenblum, who the only thing you have that he did was a year and a half or 2 years earlier said to Mr. Coppola, the factually accurate and legally authorized statement, this is a non-union building. That's all you got
So I think
from the
that
decision maker.
the fact that Coppola, is talked about by Acumen as a lifetime union member and then suddenly is confronting employees about this had to be either you or me and accusing them is circumstantial evidence that either some directive was coming from above or that he was communicating something upwards negative with respect to the union. But I think that the first one is the more likely inference that the board draws here, that there is between this statement and this accusation evidence that
There's
there's
1,000
animus from
inferences you could
Rosenblum.
draw from that. I don't understand why that one is even, I don't know why it's even reasonable to think it came from Mr. Rosenblum as opposed to Mr. Coppola wanted to make sure that it wasn't, no one was thinking it was him that did it. 'Cause
Yeah.
he does have a job limitation on it.
I mean, I would-
He thinks it's part of his job requirements.
I would contrast here from the cases that Acumen cites where junior level supervisors have not been, their animus could not be imputed upwards. So Selco was a case where there was a statement of a supervisor at a single Verizon store in Brooklyn that the board had then said could show animus of Verizon HR. And Miko was a case where there are statements of 2 supervisors at a 785-person plant. And there they said this couldn't show animus by the HR management. This case is different. Again, it's a 13-person workplace. Coppola and Rosenblum are meeting every
Then
day.
you're just taking the constructive knowledge rule and moving it over to animus, which we haven't done.
In this,
Really, all you're doing here is constructive knowledge, because there's nothing other than surmise
I would draw a distinction
that was
between
sent up the line.
I would draw a distinction between constructive knowledge, like the imputation doctrine, where there actually does not need to be affirmative circumstantial evidence. And here, where there actually is affirmative circumstantial evidence, yes, we don't have direct proof that Coppola had a conversation with Rosenblum, or that Rosenblum had a conversation with Coppola that was infected by animus, or where he was directed to make this accusation. However, we know that they were having these conversations every day. They ate lunch together every day. And there's
We know we had these conversations every day.
it's a reasonable inference for the board to have drawn.
We just don't have to have any evidence. They just go, well, this is drawn from what fact? You have to have facts to draw it from. The fact that they had lunch every day means we can assume they were talking anti-union smack during every lunch.
Again, I would point to the fact that they had a conversation at the inception of Coppola's employment regarding unionization, that the petition was shared. I think the collective evidence points to the fact that
The
there was
petition to the
animus
boss
here.
guy. Of course, you had to send that to him.
And the
That's
board,
that's not suggestive of anything.
and the board said it was unreasonable to think that during that conversation, because we know that Coppola had knowledge of Zapata's union activity, nothing at all was mentioned
You're
about that
trying to show,
activity.
again, this isn't knowledge about the union activities. You got to show animus, that the animus, that either, that put aside the questionable proposition that Coppola himself had anti-union animus given his history, but that somehow he had animus, and that animus infected information that he gave, that he sort of used that to feed the decision maker
So
information to cause him to be fired.
if we knew that Coppola had anti-union animus, for which we do from this statement, and
That statement is that's not an anti-union animus. That's just, no, I don't know. I don't want to get in trouble with my boss statement. That's not anti-union at all.
this had to be either you or me, well, this,
Yeah, because his interpretation of a conversation many months before was that it's a condition of his employment that it's a non-union place, or that he's non-union, I guess. I don't know why we would infer without any other evidence that the employer was breaking the law and saying, and don't you let any union in here. And that seems, it's just a lot to infer that someone went from an accurate and lawful statement to an illegal one, which would suggest animus. And so I just don't know how you're getting the animus, even if we say Coppola had animus, which is a stretch given his history, as opposed to fear about losing his job, how we get that animus up to Mr. Rosenblum.
so under Parsippany Hotel, this circuit has said that something that would be an 8A1 violation under the act is evidence of animus. And so when we look at what,
Is it an 81 violation to ask whether someone's involved in the union? I thought employers could do that.
so I would classify this as an accusation here, essentially saying it had to be either you or me. Coppola knew it was not him. It was an accusation against Zapata that he is the one who brought the union in. And second, when it comes to asking employees,
That doesn't get me to the decision maker having animus. That's the gap. I said, even we give you that.
Sure.
I think there's different interpretations, but even we give you and the board that because of our deference, how do we get animus up to Mr. Rosenblum?
so if Coppola had anti-union animus, he's the only source of information that Mr. Rosenblum has with respect to any information about employees' vaccination, any information about
You
unionization.
think he doctored the records?
I'm not saying he doctored the records, but I do think
just gave
he,
him the COVID records that he had that were accurate. That's not feeding him information driven by animus.
any information with respect to any of the work of the engineers was being communicated upwards from Coppola to Rosenblum. And so I think it was fair for the board to infer that if Coppola had animus, it was either coming from above or it was being communicated upwards in some
Let me
way.
ask you, counsel, I thought the evidence was that Coppola, when he was hired, had been a union man for a long time. And he's told by Rosenberg, this is a non-union building.
That's correct.
I didn't know that the board's argument or position was that it was relying on any anti-union animus of Coppola's. I thought the argument was Coppola was told when he was being employed that this was a non-union place. He became the supervisor. he knew about this union activity after Zapata came on board. He said, did you do this? And Zapata said no. All right, so I thought the argument was, well, at most, Coppola knew Zapata was lying because there was nothing that Coppola himself had done to evidence any anti-union bias. And as Judge Millett's questioning has emphasized, Coppola was merely doing his job as he interpreted Rosenberg's statement about this is a non-union building. And a reasonable inference from that, I thought, was that this is, and I'm hiring you, and there's nothing to say that Rosenberg was neutral on unionization. So Coppola's doing his job. He's interpreting what Rosenberg said. And the gap here may be that there's no evidence that Rosenberg knew that Coppola was conveying this to new employees in terms of this is a non-union building and it's going to stay a non-union building. And if you're going to be supervisor, be sure you make that clear to everyone. I thought originally that was a reasonable inference, since Rosenberg's standard operating procedure for communicating with the engineers was through Coppola. So to the extent that Rosenberg had any idea what was going on, it was coming from Coppola. And there's nothing to say that he had any concern about how Coppola was interpreting his position. But Rosenberg knew from speaking directly with Zapata that Zapata was concerned about a lot of benefits that didn't attach to his job. So then we've got this city directive. Nobody's enforcing it, so far as the engineers are concerned. Coppola says, I'll let you know when Rosenberg's enforcing it. Then we have this sort of inexplicable fact of if Rosenberg was enforcing it, looking at what the city was doing, why would he ignore Zapata's offer that he had an appointment the next day to get his vaccination? So there's no evidence that Zapata was an unsatisfactory employee. So what's the explanation for this harsh treatment? And so the answer in part is, well, he said he'd reconsider it. But when Zapata sent him those 3 emails after he got the vaccination, Rosenberg never responded. And at that point, Zapata said, well, I don't want my old job back. So this court is getting tougher and tougher on anti-union animus evidence, and we keep reversing. So this comes, the board's decision, before a lot of these reversals by our court. So that's where we are now. And that's, I think, what you're hearing in a lot of our questions.
Sure, Your Honor, and I think your characterization of the case overall is excellent. I would next turn for animus to timing, which I think your question brought up. So I think perhaps one of the key pieces of animus here is that within 2 weeks of the filing of the petition and 3 weeks before the union election, we have the firing of a known union supporter, which is on its face suspicious and gives rise to an inference of animus. Now, of course, the inference of animus here is rebuttable by an employer's explanation that it would have taken a different action. And it doesn't matter whether this happens at stage 1 of the analysis or stage 2 of the analysis, because either way, we already have an inference that timing creates. And so all the board has to do is consider the employer's proffered explanation and dismiss it. And here, the board found no alternative explanation that explained Zapata's discharge. And so moving on to the proffered explanation, Acumen says it fired Zapata because it feared penalization by the city. And the board concluded that this was not a fear that Rosenblum reasonably held for a number of reasons. One, Acumen had never seemed to fear city enforcement before in the prior 7 weeks, during which time it had no reason to think that the city would not be enforcing the policy. It repeatedly told employees it wasn't enforcing it. And it said it would alert employees when it actually began taking it seriously. When the city terminated its own unvaccinated employees, it was no indication this was a harbinger of enforcement against private businesses. And of course, Zapata had a vaccine appointment for the next day. The court has no,
Did that amount to a finding by the board that Rosenblum's stated reasons for determination were a pretext?
That's correct. And it did that pretext analysis. It characterized that proffered reason as pretext at the second stage.
So do you have authority that timing plus pretext is sufficient to prove animus?
That's right, Your Honor. So we do in this circuit, it has been held that timing alone is sufficient for a finding of animus. So that is with the Innova Health Systems case from this circuit in 2015. And Sturm Produce, which Acumen points to, is just one case where it said, well, timing here alone is not enough. But this court has held that timing alone can be enough when as evidence of animus. And then pretext on top of that is additional evidence of animus that the court can consider. The court has no further questions. The board respectfully requests full enforcement of its
More
order.
questions, Judge Rogers?
No, thank you.
Thank you very much.
Thank you.
Hey, Mr. Pegas, we'll give you 2 minutes.
Thank you. I'm not sure where those cases came from, but I mean, it's pretty clear that timing alone, and you talked about timing plus pretext, yes, but timing alone is not going to be enough to establish a prima facie case. But where is, again, the evidence of pretext here? What was just recounted, of course, we had a long discussion about Coppola's conversation with Zapata. Let me just begin there because I think that's an interesting point, which is, first of all, the question was, it had to be you or me. The comment was it had to be you or me that brought the petition to the building. Where does that evidence anti-union animus on the part of someone who is a lifetime union member, or really anybody? It's a simple inquiry. And as a supervisor, the company can, through its supervisors, it's not precluded from making inquiries about union activity. It's precluded from discriminating against people for engaging in union activity. The company has a right to know what's going on within its workforce. But this was a pretty harmless comment, if any, more like
I
a
think the
joke.
problem for you, in my view, is the pretext finding. I mean, when we tried discrimination cases, the standard jury instruction that I used to give as a district court judge was, to guide the jury. It's like, well, if the employer says that they fire someone for stealing pencils from the supply room and taking them home, and that's their grounds for whatever the adverse action is. And technically there is a policy that says you can't remove, company pencils from the site. But they know that everybody is taking pencils home. and they only discipline, Susie for doing so, then you can reasonably, you don't have to, but you could reasonably conclude that the grounds that Susie took pencils home was a pretext for the adverse action. That's just, kind of common sense. In here, if the board credited that the policy conveyed by Supervisor Coppola was that we're not really enforcing this vaccine mandate, and I'll let you know when they do start enforcing it. And so that's the policy. And yet all of a sudden they depart from that policy to terminate Zapata, at least that's the way that the board saw it. Then they are either departing from their policy or they're kind of using that policy as a pretext. And that's the board's finding. So why wasn't that pretext finding supported by substantial evidence?
Well, when you're talking about pretext, you're talking about pretext for what? Pretext to cover up discriminatory motivation. So in your example, in the, let's call it a gender discrimination case, I don't want to make too many assumptions, but since you used an employee named Susie, was the only one who was terminated for taking the pencils. Well, suppose Jill and Joan and 10 other females did the same thing but weren't fired. That would eliminate any notion that there was gender-based discrimination going on, because Susie must have been singled out for some other reason. Same thing here by analogy, pretext for what? What the board is required to prove is that it's a pretext to cover up anti-union animus. And if Mr. Coppola is providing assurances of non-enforcement before there's any union activity on the building that anybody knew about, whether it's Coppola or Rosenblum. So this is late December, early January that he's telling people, Jeff is not enforcing it yet. Mr. Rosenblum's not enforcing this yet. I'll tell you when he does. How could that be evidence of anti-union animus that when the union was not on the scene yet?
I don't think that timing undercuts the board's finding at all. The point is that that's the policy. If anything, that timing hurts your position, because if that's the policy and then all of a sudden it's not the policy anymore after the company finds out that there's union activity, then I think that makes it worse for you.
Well, I would see it differently, Your Honor. First, of course, we're still talking about Coppola here, not Rosenblum. There's no evidence that Rosenblum issued that directive to Coppola. I'm not sure, frankly.
Rosenblum's suddenly the one that changed the policy.
I'm sorry?
Rosenblum suddenly changes the policy.
Well, that's right.
Probably suddenly
Right.
changes the policy.
And what the board ignored is the intervening event, as though it didn't happen.
No, there's two possible intervening events. One was he read an article or part of an article, but didn't read all the information. Or two, that the intervening event was the petition. There's one of those two was the intervening event, and the board said, we think it's the latter.
Right. I mean, that's the sequence of events. That's the chronology, right? But we still get back to the same,
And when an employer comes up with a false reason for getting rid of somebody, which is the board's finding. I understand that's not your client's view, but taking the board's determination here, that as a factual determination, whether it's false or not, finds a false reason plus timing. So the fact that someone manufactures a reason for discharge, which on his face doesn't make a whole lot of sense when he was getting the vaccine the next day. If he stood in the office and said, I refuse, it'd be one thing. A longtime employee here, no objections to his work. You're running out of engineers as it is. And they say, no, I can't wait another 12 hours for you to get your vaccine. And that they say that is itself, lying is evidence of animus too, combined with the timing is what the board's rationale is. Why doesn't that suffice for animus?
Well, I understand your point, but the directive from Mr. Rosenblum to Mr. Zapata was come to my office with your vaccination card or your request for an exemption. He didn't get that. Now, one can quibble or argue over whether he treated him fairly.
He got an appointment.
I'm sorry?
He got an appointment.
He said he had an appointment.
He took door number 3. I guess your point is he was given 2 doors and he tried to create a 3rd door.
Well, I mean, Mr. Rosenblum asked for one of two things. He got neither, right? So again,
He was
could,
afraid New York City was going to come break down his door that afternoon and say, you only got one employee out of compliance, and because yeah, but he's going to
Well, he-
vaccination tomorrow, that they were going to throw him in jail
Well,
outside the company.
listen, he just read that the city had literally fired 1,000 workers for not being vaccinated.
Mhm.
He has New York City departments as tenants in his
Mhm.
building, including the NYPD. Did he know they were going to knock on his door that day or the next day?
NYPD wasn't running around enforcing this thing.
I'm sorry?
It doesn't make, I don't even understand that rationale. I've got other people in the building. I don't understand that rationale.
Well, he was concerned if the city was enforcing it against its own employees,
Mhm.
that his building might be a target because they have
Yeah, but it would have
city
to be
tenants.
it would have to be a target like within hours.
Not necessarily.
Because as of the next day, he's going to be in full compliance once the body gets his vaccine.
Well, you know, he certainly had questions in his mind as to whether Mr. Zapata was being sincere about getting the vaccination at that
That's why
point.
he's saying.
So he decided to,
You only got to wait a few hours for that. You only got to wait a few hours to figure that out.
fair enough. He could have done this
As a
differently.
lawyer, you wouldn't have told him that you're gonna get enforced and they're gonna fine you or anything when you've got 99% compliance and the one person who wasn't is actually getting vaccinated within hours.
Again, I'm not here to argue that
Mhm.
this was the only way to go. You know, our position is that right, wrong, fair, unfair, there's no evidence that is in this record that would allow for the conclusion that Mr. Rosenblum, as the decision maker, harbored discriminatory animus. It's really just a timing case, and timing doesn't do it. You know, it's also based on information that there's no evidence Rosenblum had about what the city was doing before they started firing people. You know, the board asked the court to take judicial notice of something there was no evidence Rosenblum ever looked at or read or had any idea that people were not were being, I guess, put on leave or whatever the city was doing before February 14th, I believe it was, of 2022. So, you know, it's kind of inference upon inference upon inference, but it really doesn't get to his, you know, his animus, and certainly Coppola's conversation with Zapata doesn't get him there. And I think Your Honor was 100% correct about the protected nature of Rosenblum's conversation with Coppola, which, you know, doesn't really get the board very far.
Any other questions, Judge Rogers?
No, thank you.
Thank you very much.
Thank you,
counsel.
appreciate it.
Case is submitted.
The Honorable Court now stands adjourned until this afternoon at 2 p.m.